Contracts 1. Rules Summary. Choice of law. The first issue is whether a contract is governed by the Uniform Commercial Code UCC or the common law CL. Sale of goods is the transfer of title of a good that is tangible, movable item at the time of sale from buyer to seller for a price. The UCC contract is formed upon agreement to sell a good for a price or upon actual delivery of payment of the good, or actual delivery of payment or actual delivery of the good. It promotes certainty, and it also promotes freedom of autonomy and private ordering. The predominant purpose test determines what type of contract are between parties. Is it a UCC goods contract or a common law everything else contract, such as services? Courts look at the language, the nature of service or sale, and the intent of the parties to determine the choice of law. See Lohman v. Wagner. Offer, whether they completed mutual assent when they agree to whatever they agree to. Common law. So in common law, you need offer, acceptance, and consideration. The contract must be definite or convey intent to be bound, certain, or provide neutral third party with a method to determine when a contract is breached and how to provide remedy. That is offer. Acceptance. The second step to find mutual assent is the unequivocal manifestation of intent to enter a agreement on the identical terms proposed by the offeror. This is the mirror image rule. Offer creates power of acceptance and mutual assent. And mutual assent is the moment the offeree sends their acceptance. Courts find mutual assent by objective conduct and not subjective testimony, relying on the party's credibility. That is acceptance. Consideration. Whether sufficient consideration when they agree to pay whatever money for whatever thing is determined by the bargained for exchange, which equals consideration. Also, the parties must mutually induce each reciprocal promise. With a nominal consideration, courts accept the free market exchange unless the consideration couldn't objectively induce the party to agree. In the common law, consideration is the line between enforceable and unenforceable agreements. See Otis Wood versus Lady Lucy Duff Gordon case. That is consideration. Modification. Whether modification is enforceable when so-and-so tells so-and-so that this and that will change or happen. Modifications equal a contract and must have consideration. This rule is under the common law. So again, in common law, modifications are a contract and they must have new consideration. Parties must perform obligations for the consideration that induce them to enter the first contract, because performance pre-existing duties can't amount to a valid new consideration. Again, because performance of pre-existing duties can't amount to valid new consideration, the parties must perform obligations for the consideration that induced them to enter the first contract. Mutual assent to a modification does not happen under a common law. It does not create a binding modification common law contract. Binding requirements exist for a contract to be binding that has modifications in the common law. it's required that there be a change in circumstances that are unforeseen by the party seeking to enforce the modification and at the time the original agreement was entered. If circumstances present, then the common law will enforce a modification. The Uniform Commercial Code does not require added consideration to be binding. Did parties foresee the modification and risk? One party may rely on another's knowledge. That is modification. Statute of frauds. Whether agreement enforceable with regard to being reduced to writing. Common law. The statute of frauds requires contracts that involve SLIGEM. SLIGEM is an acronym used to recall the type of contracts that are needed to be reduced to writing for the statute of frauds. So, SLIGEM in writing by a party whose performance is sought is required under the statute of frauds. The contracts have to identify the subject matter of the contract. They must list essential terms. They must state the offer or contract made, and they must be signed by the party to be charged. The exceptions to the statute of frauds are many, including reliance, partial performance, and judicial admission. There is something called extrinsic evidence that can be admitted only to determine the meaning of the terms and to decide whether the writing was essential or has essential terms. A case that shows extrinsic evidence being used is Sterling versus Taylor. And this proved that extrinsic evidence can't be used to supply non-existent terms. To violate this rule would undermine the objective theory of contracts. If the court were to allow extrinsic evidence to supply terms not included in the contract, statute of frauds would not serve stated purpose of preventing fraudulent testimony and resolving disputes over contracts involving SLIGEM. And SLIGEM stands for surety, land, contracts that take a year or more to complete in the terms, goods that are $500 or more, executorship, and marriage. The arguments for and against statute of frauds. How does one set of facts meet or not meet exceptions? So just to clarify, extrinsic evidence is evidence relating to matters referred to in a document that's not itself included in that document. That is statute of frauds. Defenses to enforcement. Mental cognition. Whether one can avoid the contract under existence of a mental disability that impairs their cognition, can't understand contract terms, other has reason to know that the other person can't behave reasonably in relation to the contract, incur only voidable contractual duties. This defense is unavailable if enforcing the contract would result in unjust or materially unfair change in circumstances on behalf of the non-disabled, and non-disabled would suffer undue hardship by rescission of the contract. That is the defense of mental cognition. The defense of intoxication does not have a similar unfairness defense as mental cognition. Would this defense be asserted? If this happened, it has to be determined by the court whether the contract is going to be enforceable or unenforceable. That is the defense of intoxication with regards to contract enforceability. The defense of mistake. A contract is voidable for either a mutual or unilateral mistake. The belief not in accordance with the facts is a mistake. Both require mistake to address a basic assumption underlying the contract, and the parties seeking to avoid the enforcement must not bear the risk. Unilateral mistake is when one causes the mistake that must be somehow at fault or responsible. Parties bear the risk when they have opportunity to examine a particular facts but choose not to, or when agreement allocates the risk to them, or the contract decides the risk should be allocated to them. A contract may be avoidable if all elements of either are present. That is mistake, which is a defense to enforceability. Unenforceability because of violation of public policy. Whether to enforce agreements on the grounds of public policy, which include promissory estoppel and unjust enrichment, are equitable causes of action. Factors include where the parties are justified in their expectations, any forfeiture that would result if enforcement were denied, any special public interest in the enforcement of the particular term. The court considers the following in weighing against enforcing a term. 1. Strength of policy manifested by legislation or judicial decisions. 2. Likelihood that refusal to enforce the term will further that policy. 3. The seriousness of misconduct involved and the extent to which it was deliberate. And 4. The directness of the misconduct between the circumstances and the term. The court considers these items and they weigh them to see if the term should be enforced. Promissory estoppel and unjust enrichment are in the common law to prevent frustrating the intent of parties. It's also there to preserve reliance and prevent unjust enrichment and promote the promotion of caution in contractual relations. Sacrifice the policy interests requiring evidence and more efficient channeling disputes for judicial determination, and that they don't require written contracts, and determining claims for either are based predominantly on testimony as opposed to written contracts. So for clarification, promissory estoppel and unjust enrichment in the common law sacrifices the policy interests requiring evidence and more efficient channeling disputes for judicial determination, and that they don't require written contracts, and determining claims for either are based predominantly on testimony as opposed to written contracts. Promissory estoppel and unjust enrichment serve to encourage belief that the judicial system will enforce reasonable expectations and reliance. Unjust enrichment at their expense, and promoting the actual, objectively expressed intent of the parties to the contract. Policy. So that is enforcement because that is unenforcement because of violation of public policy. And promissory estoppel and unjust enrichment are exceptions. Policy. This defense protects components of contract law. Capacity-based defenses, minority, intoxication, mental diagnosis, protects contract law's respect for private autonomy and encourages those seen as lacking in the caution necessary to enter a contract seek care and protection of those whom the law believes is capable of exercising the requisite caution. These equitable claims and defenses arise with the understanding that common law or contract is an incomplete system of regulating private agreements, and added more flexible rules needed to address situations where parties have been induced to rely on promises to a detriment or doing something for their benefit and not others. If arguments based, solely on common law rather than the Uniform Commercial Code, that is policy. Rather, that is the policy defense. Equity promissory estoppel. A promise is a manifestation to act or refrain from acting in a specified manner. Court will enforce an expenditure made in reliance on a party's promise so long as a promise was made, reliance on promise was reasonable and foreseeable based on the substance of the promise, and the reliance was detrimental. Many courts require the specific reliance incurred by the complaining party to have been foreseeable by the party making the promise. Whether reliance on an offer can render it irrevocable, well, in the common law, the option contract requires separate consideration, and option contracts are typically not revocable. They are irrevocable. That is equity promissory estoppel. Equity unjust enrichment. Courts allow party to recover for providing value to another party if it was provided under circumstances that the party should expect to pay for it, and allowing the party to retain it would be unjust. If promise follows the receipt of the benefit, courts will typically enforce promise to pay for services or benefits received. Sometimes courts will allow a party that breached the contract to recoup the value they conferred on their cry of unjust enrichment. That is equity unjust enrichment. Waiver. Courts will not allow parties to assert rights they have a contractual right to, but have taken action directly in contradiction to asserting those rights, particularly when the action is reasonably relied on by other party in changing their position. This is ultimately another form of promissory estoppel, also known as waiver by estoppel. This is waiver. The first issue to determine if an agreement is enforceable in a court of law is to see what type of contract it is. And let's first define contract. A contract is a legally enforceable exchange of promises between two or more parties. It is an agreement for the breach of which the law provides the remedy. So the first issue to determine is the governing law or choice of law. It is the first issue. So the idea is to determine, is it a good? Is it a service? If it's a good, then there must be a sale, there must be a transfer of title, and there must be a price. To answer whether a contract is about a good or not, or a service, is to perform the predominant purpose test. Ask yourself, is it a bunch of services that lead to a good, or is it a service? Policy considerations include it must promote economic efficiency for the UCC, or Uniform Commercial Code, which is paramount. They want, and when I say they, the court, the Anglo-American law wants people to buy goods. They want to establish a high level of predictability to set expectations about those goods. They also want to promote the two main policies they want to promote is economic efficiency and predictability. So with regards to the choice of law, it's determined by the predominant purpose test. So choice of law is under the Uniform Commercial Code is about the sale of goods, transfer of title of a good. A good is a tangible, movable item at the time of the sale. A contract formed under agreement of sale of goods for price or actual delivery of payment. And if, a contract involves goods and services, the predominant language of a contract, the nature of services, sales, and intent determines what type of contract it is, sales or sale of goods or services. So the court prefers to promote certainty in a transaction. Under the common law, juxtaposed to Uniform Commercial Code or UCC, all other forms of agreement are under the common law, such as services, including the sale of a business is under common law. For clarification, the sale of a house is under common law. So what is contract formation and what is the objective theory? Well, under the objective theory, a contract is offer and acceptance, which equals mutual assent, plus consideration. This is contract formation. Contract formation is found in UCC Section 2, 207. Choice of law is found under UCC Article 2 or the common law. So, an offer is a manifestation of willingness to enter into a bargain made so that another is justified, and understanding that his assent to the bargain is invited and will conclude it. The acceptance part of the equation is the party to sale of goods may communicate assent adding new or different terms without terminating the power of acceptance. This is under UCC Article 2. So with regards to new and different terms, the agreement only on matching terms. New terms are proposals. Differing terms are knocked out, and this is true under the common law. Merchants are merchants involved in the agreement. New terms included unless the offer prohibits terms materially change the deal or rejection communicated. And this is true under the UCC Section 2207 for offer and acceptance. So there are one or three exceptions with regards to the offer and acceptance section of the equation. New terms are not added. The contract exists on matching terms. This is the mirror image rule. And there are gap fillers available if applicable. And furtherance to our discussion of the formation of contracts, there are requirements that a contract must have can be unilateral or bilateral. So a bilateral contract is where offer is accepted by return of promise. A unilateral contract is when one party completes performance. Reward offers are contracts or ads offering a reward. Anyone who performs the condition accepts the agreement and accepts the terms. The duration of an offer, generally the time for acceptance from the date offer received. An option contract is irrevocable offers. Offerer accepts consideration in exchange for a promise to keep offer open for a time. So let's dig further into the offer portion of the contract formation formula or equation. So with regards to an offer, offers must be definite. The offer has to express commitment, and revocation is possible until the offer is accepted by the offeree. Recitals, which are the portion of the contract that says, we hereby so and so. Recitals are a way for definiteness to be met in a contract. Offers can omit some specificity so that it is not a binding offer. One can disclaim intent in a communication that would have been an offer. Offers are not advertisements. Advertisements are invitations to enter negotiations. Advertisements are notice. Advertisements are solicitation for offers that create no power of acceptance. This is to not put a burden on advertising entities to provide products and services beyond the volume if many people respond to accept their offer. Offers are also not jokes, inquiries, or quotes. Offers are a manifestation of the willingness to enter a bargain that is clear to another that their assent to the bargain is invited and will conclude it. A manifestation to mutual assent to exchange is usually when an offer or proposal is made and accepted by offeree. Offers are also, after the fact, a manifestation of mutual assent without offer or acceptance identified at the moment of formation. One can't be determined. That is, the exchange of value after offer and acceptance. So what is needed for an offer? Intent to be bound and accept terms, and there must be definiteness and certainty. or the terms of breach with remedy are present. This is the objective theory. Offers, however, do terminate. For example, so offers do give the offeree continuing power to complete the manifestation of mutual assent by acceptance of offer. However, they terminate by rejection or counter offer. They also terminate by lapse of time or revocation by offerer or by death or incapacity of either party. Offers terminate by non occurrence of any condition of acceptance under terms of the offer, or the offer expires under its own terms, or the next communication is another offer. Offers are not terminated if the offeree manifests a contrary intention to take under further advisement. So basically, that says, let me think about it. That is not a termination of an offer. So when does, termination of an offer occur? Continued. Either party with power by agreement or law ends the contract for something other than breach. That is another way a contract can be terminated. All obligations still executory on both sides are discharged. That is another way to terminate a contract. Any right based on prior breach or performance survives. Also, termination is by performance of promises and duties. That's a nice way to terminate a contract. Also, a offer is terminated by mutual rescission, mutual agreement. As long as there are executory duties on each side, relinquishment is supported by consideration. So, termination of offer is also found in rescission that may be subject to the vested third party's rights. Also, the destruction of the subject matter of the contract, supervening illegality of the contract, and death or insanity of either party is a termination of the offer. With regards to the offeree's counter offer, this relates to the same matter as the original offer, and it proposes a different substitute bargain. The offeree's power of acceptance is terminated by a counter offer unless the offerer manifested contrary intention to take the offer under further advisement. Also, the offeree manifests contrary intent to take their manifestation of intent under further advisement. This is to counteroffer. But let's just remind ourselves: offers are created. Offers create the power of acceptance. Mutual assent is supplied when the offeree sends acceptance. What can substitute an offer? Promissory estoppel. Promissory estoppel can substitute an offer. It can also substitute acceptance and consideration. Offers in the UCC for goods. If offer says this offer is limited to terms herein, then the parties cannot add or subtract terms to the original agreement. So let's now dive into acceptance. First, we'll start off with the offer and acceptance together, and then we'll branch off into acceptance. So what happens when goods are being transferred, but we cannot see when the parties decided that they want to buy this amount of goods with this amount of money? To answer this, we have to look to the common law. We have to look at the offer, the acceptance, and the consideration, the whole equation. So the policy items that we're going to look at for this offer and acceptance is private ordering, channeling, and as well as standardization. So the policy regarding private ordering: the right to create and enter a contract respecting private autonomy and freedom of contract. The policy regarding channeling is promoting channeling of private disputes. And channeling basically is to provide a line where courts will enforce agreements with mutual induced bargain for exchange and will enforce agreement without the mutually induced bargain for exchange. Also, the third policy to consider is, with regards to offer and acceptance, is standardize the way you enter a contract and how a court analyzes how you got into a contract. Again, acceptance. Party to sale of goods under the UCC may communicate assent adding new or different terms without terminating the power to accept. However, under the common law, when there are new or different terms, the agreement only on matching terms are part of the binding contract in the common law. This is total opposite to the UCC. The new terms under common law are only proposals, and differing terms are knocked out because common law demands the mirror image rule unless there are special circumstances to allow modification. Just to be clear, mutual assent is when there is offer and acceptance. They mutually assent to the same agreement. So, under mutual assent, contracts in the modern era, the rule is manifestation of assent to online contracts. They're not meaningfully different from non online contracts. These contracts are accomplished with words, with silence, with action, and with inaction. As long as the user intends to engage in the conduct and knows or has reason to know that the other party infers conduct as their assent, then there is mutual assent. Offeror can't assent unless the offeree knows of the offer. When there is no notice of the contract terms, the offeree is still bound by provision if on inquiry notice of terms and assents by conduct that a reasonable person would say is assent. And that's to say, that's saying even if the offerer doesn't provide notice of the contract terms, the offeree, the person who's like basically clicking I agree, is still bound by the provision if on inquiry, or that's to say they're still bound by the provision if they actually research and read those terms of agreement and the notice of the terms and their conduct after clicking I agree. Those are reasonable ways to prove a binding online contract. That's where a reasonable person would say that there is assent. The contract terms were there. The person who clicked I agree just didn't read them. However, the person who did click I agree, the offeree, is still bound by those terms. Again, mutual assent is when there is offer and acceptance. Mutual assent specifically is the objective meeting of the minds between the offeree and offeror. So there are times when there is friction between offer and acceptance, such as in Quake Construction versus American Airlines. That was when, like, if parties say execution of a formal agreement is a condition precedent, then there is no contract until the formal agreement is executed or written. Also, under Houston Dairy versus John Hancock Mutual Life Insurance Company, acceptance of an offer is invalid unless it is communicated to the offeror. And a case called Rogers Backhoe Services versus Nichols, an implied contract may exist despite the absence of an express agreement between the parties. With regards to acceptance, there's something called the mirror image rule, and it exists only in the common law. So the acceptance common law mirror image rule is where acceptance is exact reflection of the offer. The differences between the offer and acceptance can be in method or terms of acceptance. The common law refuses to recognize qualified or conditional assent to an offer as acceptance. So conditional acceptance clause converts acceptance into a counteroffer. This wants offerors assent to added or different terms. The common law does not allow this. The last shot rule is the mirror image rule. Whatever the last terms conveyed, that are the ruling terms. So let's take a side-by-side view of acceptance between common law and the Uniform Commercial Code. So, under common law, offer and acceptance includes must mirror terms. The mirror image rule applies. Added or different terms equal a counteroffer and a termination of the offer. Methods of acceptance. Bilateral contract seeks acceptance by return of promise or performance. In a unilateral contract, the contract is bound by performance. Acceptance by silence or conduct is also binding in the common law, and that is found under Rogers, Badco Services versus Nichols. Silence is not acceptance. An express contract is formed by words. This may sound contradictory to what I just said, but acceptance by silence or conduct is a contract. However, silence is not acceptance of the terms. An express contract is formed by words. The exception is silence may be acceptance if an implied in fact contract is formed by conduct. So conduct is the pivot between silence being a binding contract and silence not being a binding contract. Conduct, conduct, conduct. Exception to acceptance by silence. Continued. Trade practice. If it's common to the trade practice, if it's common to that field of business where silence is acceptance, then silence is acceptance. The offeree takes the benefit. That is another way to prove that silence is acceptance under the common law. It's when the offeree takes the benefit. All right, let's look at offer and acceptance, particularly acceptance under the UCC Uniform Commercial Code for Goods. Acceptance is not mirror image rule. Parties may choose to use the mirror image rule. An acceptance that adds terms to the offer is valid. With regards to offer and acceptance between merchants in the Uniform Commercial Code for Goods, if it's between merchants, the additional terms become part of the contract unless they materially alter the contract or the offeror objects to the changes, or the offer is limited to its terms, and that's where you get into battle of the forms. So a Uniform Commercial Code offer and acceptance, it must be definite and seasonable expression of acceptance or written confirmation sent in reasonable time. So that's all about definiteness and timeliness. Under UCC, acceptance operates as acceptance even if states terms added or different from those offered or agreed to, and that's the opposite of the mirror image rule. There's offer and acceptance under UCC unless acceptance is expressly made conditional on assent to the added different terms. That's to say, if you don't accept these terms, then we don't have a contract. Well, that's a condition. Either I accept the terms on your condition or we don't have a contract. So that says, unless acceptance is expressly made conditional on assent to the added different terms, then the UCC contract is not binding. These are not counteroffers. So under UCC, change in terms are not counteroffers. Conduct can create a contract. Just like in common law, conduct can create a contract. There can also be acceptance by what's called the mailbox rule or the dispatch rule. Mailbox rule acceptance is valid when sent. An exception to this is if the offeror drops out and the rejection is sent first before the acceptance. So the mailbox rule, acceptance valid when sent. If acceptance is sent before revocation is received, there is a contract. There is acceptance. When out of possession of the offeree in a reasonable medium, that is acceptance. Acceptance continues through the mailbox rule by saying qualification that offer must be seasonably dispatched and received within a normal time frame. The mailbox rule also says there is an exception. If the offer stipulates acceptance is not effective until received, then that is the case for that agreement. So just to reiterate, under the mailbox rule, acceptance is valid when it is sent before the revocation is received. Acceptance is valid when it is out of the possession of the offeree in a seasonable medium or reasonable medium. And acceptance is valid when there's a qualification that the offer must be seasonably dispatched and received within a normal time frame. An exception to acceptance via the mailbox rule is if the offer stipulates acceptance is not effective until it is received, juxtaposed to when it is sent. So as I said before, mutual assent is offer and acceptance. However, there are defenses to enforcement based on a lack of mutual assent. Things like information asymmetry, mistakes, different kinds of mistakes, fraud, and we'll go into those one by one. So information asymmetry is acceptable. In Anglo-American courts, they don't require everyone to disclose all of the information they have when they are litigating a contract. Anglo-American courts have incentivized competitive advantage. Courts don't want all parties to know all of each other's information. Information asymmetry is unacceptable when there are circumstances where the court will intervene based on asymmetrical information. If you bear the risk, you cannot use this defense. If there's a mutual mistake, unilateral mistake, a court will enforce a contract based on that type of asymmetrical information. However, they will not enforce a contract where there is fraudulent misrepresentation and fraudulent concealment. So the different type of mistakes include mutual mistake, unilateral mistake, but then we get into mistakes like fraud, fraudulent misrepresentation, and fraudulent concealment. So under mistake, there's mutual mistake. It's a defense. So a mutual mistake is a mistake of both parties that relates to the basic assumption on which the contract was made. The material effect on the agreed exchange is present. A party seeking avoidance, the defending party, which is the party seeking avoidance of the enforcement of the contract, did not bear risk of the mistake in the contractual terms. The material effect on agreed exchange may consider any available relief other than voiding the contract. A case for this is Elsinore Union Elementary School District versus Castorf. So unilateral mistake. This is also a defense to enforcement under mutual assent, just like mutual mistake. So unilateral mistake is mistake of one party relates to the basic assumption on which the contract was made. The material effects on the agreed exchange adverse to the mistaken party. The mistaken party did not bear the risk of mistake in the contractual terms, and the effect is policy unconscionable, or the non-mistaken party had a reason to know of the other's mistake, or the non-mistaken party's fault caused the other party's mistake. So reason to know does not equal actual knowledge. Unilateral mistake is when the non-mistaken party caused the mistaken party to misthink, or the judge finds unmistaken party's conduct unconscionable. Promissory estoppel may kick in to enforce the contract for the mistaken party. So there's fraudulent misrepresentation. This is a defense and a cause of action. A false statement or representation of fact made by one party to another. The misrepresentation relates to a fact that is material to the exchange. The misrepresentation is intended to induce the other party to enter the contract. The party seeking to avoid the contract reasonably relied on the misrepresentation in entering the contract. A misrepresentation is material if it would be likely to induce a reasonable person to manifest his assent, or if the maker knows that it would be likely to induce the recipient to do so. This requires fraudulent intent. A case for the fraudulent misrepresentation is it's not very common. It's very egregious, quite blatant once you dig into the facts. But with regards to the Red Owl Stores case, there was no evidence that intent to fraud was present. And in the Red Owl Stores case, promissory estoppel then kicked in. So, damages when it comes to fraudulent misrepresentation are punitive damages and constructive trust. This is for fraudulent concealment and fraudulent misrepresentation. So, now let's get into fraudulent concealment. This is a really bad one. It's a defense as well as a cause of action. It is when there is a failure to disclose a fact that amounts to a misrepresentation when the party knows the disclosure of the fact is necessary to prevent some serious or to prevent some previous assertion from being a misrepresentation or from being fraudulent or material. This is fraudulent concealment is where he or she knows that disclosure of the fact would correct a mistake if the other party, as to a basic assumption on which the party is making the contract, and if no disclosure of the fact amounts to a failure to act in good faith and in accordance with reasonable standards of fair dealing. Please notice my emphasis. Fraudulent concealment continues when where he or she knows that disclosure of the fact would correct a mistake if the other party, as to the contents or effect of a writing, evidence, or embodying of an agreement in whole or in part, where the other person is entitled to know the fact because of a relationship of trust and confidence between the parties. Fraudulent intent is required for fraudulent concealment rather than unilateral mistake. Also categorized under mistake is promissory fraud. That's when someone makes a promise that they do not intend to keep. Then there's minority, capacity, intoxication. These are not equitable defenses. Equitable is when a judge gets to apply the facts to the law. So, violation of public policy are also defenses. A contract that completely violates a statute is not a contract. It is a defense to the enforceability of a contract. For example, contract for murder. Case includes Berlanghieri versus Running Elk Corporation. This is a case that talks about when the statute shows that a contract is in violation of the statute. So in this situation, there was a holding a lodge with horse riding harmless for any liability. So basically, Running Elk Corporation tried to say that the people who came to their horse riding lodge, if they would have to sign a contract, that would hold the lodge harmless or not liable for any liabilities. And this was a violation of public policy. This was not an enforceable contract because it violated a statute. Defenses to enforcement include incapacity, infancy, mental defects, intoxication, duress, and undue influence. Also, the statute of fraud is another defense to enforcement. If a agreement has to be reduced to writing by law and it's not reduced to writing, then it's a defense to enforceability. It will not be enforced, likely. Okay, let's dive into consideration. In a preview, the case Lady Duff Gordon, the court looks for consideration. Promissory estoppel, as well as pre-existing duty, replaces consideration in a contract. Illusory promise, this is where there actually was no contract and no consideration. Past consideration does not create a contract. Moral consideration does not create a contract. The thing that you are promising could be the relinquishment of a right, as was the situation in the case of Hammer v. Sidway, or a trade of a risk, which is a contract with consideration. So, with regards to policy, the policy items that apply to consideration are unjust enrichment, minor policy application, economic efficiency, minor policy application, channeling, which provides a line where courts will enforce agreements with mutual induced bargain for exchange and they won't enforce agreements without mutually induced bargain for exchange. Consideration is next. So, with regards to consideration, which is the bargain for exchange requirement, it's required for a valid contract. So, it is not a gift. It means a bargain for exchange of promises or performance. It must be mutually induced, which means each party's promise or performance must induce the others. Consideration or the bargain for exchange, promised or provided performance may consist of affirmative act, forbearance to do something a party has a legal right to do, or creating, modifying, or terminating some legal relationship. This includes detriment to promisee or legal benefit to promisor. The promise or performance may be given by the promisor to a third party and to the promisee or a third party. Consideration adequacy. Exchanges of value generally make for adequate consideration. The values do not have to be equivalent or even roughly equivalent. However, grossly inadequate consideration may evidence fraud or that one party lacked the capacity to enter a contract. Nominal consideration is the nominal or the named amount of consideration can't form a contract if the bargain is mere pretense. An example of this is when a mother wins the lottery, yay, and she promises to give her daughter $1 million. And so the mom, to do this, buys a pencil from the daughter that is worth only 1 cent for $1 million. In this situation, there is no contract because the mother who won the lottery only named consideration or gave nominal consideration out of mere pretense. So there are limitations to what is considered consideration. Things like past consideration is generally invalid under the pre-existing duty rule. So past consideration or moral obligation does not equal a contract. There is no consideration. If the offeror's promise is made in recognition of a benefit already conferred by the offeree, then the promise is not consideration. There is no contract. Any moral obligation to fulfill a promise in response to past consideration is not legally enforceable. Illusory promise. When a promise allows the promisor to choose an alternative that does not have sufficient consideration, is an illusory promise. This is where the promisor can choose whether to perform at all because the promisor reserves a choice of alternative performance which is not sufficient consideration, unless each of the alternatives would be sufficient consideration if offered alone. An example of this would be an act of extortion or blackmail. It's like either you pay me $1 million or I'm going to tell your wife that you're cheating on her. Well, the person who's given this offer can say, I can pay this person $1 million to avoid them from telling my wife that I'm cheating on her, or I could just not pay her the $1 million and still not tell my wife I'm cheating on her or tell her myself. So because the person being extorted or blackmailed has the option or the alternatives to pay the $1 million or not, that is not a contract. That is an illusory promise. The pre-existing duty rule is performance of a legal duty that is already owed is generally insufficient for consideration. This is not a contract. Modification to an existing contract is generally unenforceable under the UCC. without new consideration, except if altering duties, unforeseen circumstances, and sale of goods. Now, let me say that again. Modification. Modification to an existing contract is generally unenforceable if there is no new consideration, except if they are altering duties, if there are unforeseen circumstances, or if there is a sale of goods. That's to say, modification is not a contract without consideration under the common law. Modification without new consideration is still a contract under UCC, sale of goods. So consideration substitutes are, again, promissory estoppel, statutory substitutes, and detrimental reliance. These are all substitutes to consideration. Now you may be asking, what is promissory estoppel? You mentioned it several times during this video. I want to know what it is. So promissory estoppel is a doctrine that may permit enforcement of a promise without consideration if the promisor reasonably expects or should reasonably expect the promisee to rely on, or it induced an act or forbearance from the promisee. Promissory estoppel continues. The promisee, in fact, relies on the promise by performing a definite and substantial act or forbearance, and as a result, the promisee suffers substantial detriment. Any benefit received by the promisee is irrelevant. The policy associated with promissory estoppel is the court will give limited remedy to prevent injustice. It is limited to the extent of the detriment, which is the actual loss, and may not encompass the full value of the performance or of the promise. An example of the limited remedy is, say, a landlord and a tenant sign a lease agreement. The tenant pays, the lease agreement says $1,000 a month for 12 months. That's $12,000 total. So the tenant, they pay the first month's rent, about $1,000, but then they don't pay for the next 3 months. Well, the landlord can't say, oh, I need my $11,000. It's like, no, they didn't pay for 3 months, so you only get $3,000, not the $11,000. That is, it is limited to the extent of the detriment, the $3,000, which is the actual loss, and may not encompass the full value of the promise, which is $12,000 or 11 remaining thousand. Another limit to consideration, which is the third element in our contract formation formula, is unjust enrichment. This can be found in the case of Webb v. McGowan or Harrington v. Taylor. Let's see. So unjust enrichment is when restitution prevents unjust enrichment. Unjust enrichment is unfair for one party to retain the benefit without compensation. Generally, the recovery is the value of the benefit conferred on the recipient, not the loss to the party seeking restitution. The injured party is entitled to restitution whether or not there's an enforceable agreement. This is usually monetary. One party confers a benefit on another, and under the circumstances, it would be unfair to permit the other party to retain the benefit without compensation, usually because the other party knew or had reason to know that the other party conferring the benefit reasonably expected compensation. Usually the benefit was not intended to be a gift. And if you're really curious, the word confer, CONFER, means to grant or bestow. To wrap up contract formation, offer acceptance and consideration, let's look into other types of contracts, such as contract implied in fact, contract implied in law, express contracts, and implied contracts. But let's just step back for a bit. So contracts in the modern era. So when it comes to like what we call click wrap or online contracts, click this to agree, click this to I have read the terms and agreement. So, failure to read an enforceable clip wrap agreement will not, I repeat, will not excuse compliance with the terms. And this is true absent fraud. And so let's go into contracts are express when they are orally stated and when their terms are orally stated with offer acceptance and consideration. Contracts are implied when parties don't state terms. So a contract implied, in fact, is when conduct implies a contract with offer, acceptance, and consideration. This is the objective theory of contracts. Contracts implied in law are when the law implies obligation, unjust enrichment, and promissory estoppel. So implied and expressed are based on the way parties manifest mutual assent. So no implied in fact contract if there is an express contract covering the same subject matter. This wraps up formation of contract and types of contracts for Contract Law 1. Enforceability of a contract. Generally, enforceable contracts are upon the formation of the contract. The statute of fraud requirements still apply. Void versus voidable contracts. There are some defenses to enforceability. If the contract is already established, then the contract can be rendered void or voidable. Void contracts, or contracts that can be voided, is where a court treats parties like the contract never formed. However, a contract is voidable if the contract remains valid until the aggrieved party chooses to disaffirm it. Defenses to enforceability: lack of capacity, improper threats leaving no reasonable alternative except to assent. There's also duress, infancy, mental illness or defect, and intoxication. Undue influence is another defense to enforceability. This is where there is an unfair or excessive persuasion by the dominant party due to a relationship. Also, there's illegality is another defense to enforceability. Also, unconscionability is a defense, and misrepresentation, which is untrue assertion that's fraudulent or material. There are ambiguities that can be present in a contract that would prevent it from being enforced. For example, patent on the face of a contract type of ambiguity, and latent if agreement is clear on its face but admits to multiple reasonable interpretations in light of circumstances. Those are examples of ambiguities, patent and latent. Rules of construction. Clear and express language is required. Parties' intent and purpose are required in a contract. Words and conduct are required to be explicitly implied or expressed in a contract. Favoring lawful, effective construction. There must be a specific over general terms put into the contract when it's being constructed. Also, negotiated terms over boilerplate terms are preferred when you are constructing a contract. And when it talks about boilerplate, it means standardized, preformed, or form language. That means boilerplate. Pretty much copy and paste from a pre-existing template. The course of performance must also be part of the construction of a contract. The course of dealing as well as customs usage are the rules of constructing a contract. Clarifying terms are terms of a contract that must be reasonably certain for a court to enforce the agreement. Court must clarify indefinite, ambiguous, or omitted terms. Essential terms are subject matter, price or other consideration that can be nominal, fixed, or a formula. Also, the quantity must be in the contract because it is an essential term. Continuing the contract duration and timing of each party's performance are essential terms to a contract. So the general obligation of good faith and fair dealing means in all contracts, law implies the obligation that all parties exercise good faith and fair dealing. Breach by conduct contrary to the contract violate spirit of contract by unfairly, unjustly, or opportunistically defeating the other party's contractual expectations or unfairly failing to cooperate to enable the other party to perform honestly. And honesty is part of the general obligation of good faith and fair dealing. The UCC parole evidence rule. This includes parties' writings agree on a particular term or what's in writing is the expression of their final agreements. Any prior agreements or oral agreements are inadmissible to contradict terms. Specific evidence is admissible to explain or supplement the terms. Course of performance can be used to supplement the terms. Course of dealing, usage of trade, or evidence of consistent added terms, unless the court says the agreement is completely integrated. And by completely integrated, they mean a record of the full expression of parties' intent, which is the completed integrated definition. To reiterate, specific evidence that is admissible to explain or supplement the terms include course of performance, course of dealing, usage of trade, or evidence of consistent added terms unless the court says the agreement is completely integrated. With regards to enforceability, we're now going to go into conditions. So, a party may avoid performance if a condition hasn't occurred and it is not excused. The other party is not entitled to a remedy for breach due to non-performance. Under the Uniform Commercial Code, a buyer can revoke acceptance. So under Article 2 of the UCC, if goods fail to conform to the contract in any way, the buyer may reject them. Once goods are accepted, the buyer's power to reject them is generally terminated, and the buyer is obligated to pay the price less any damages from the seller's breach. However, a buyer may revoke an acceptance if the goods have a defect that substantially impairs their value to him, and he accepts them because of the difficulty of discovering the defects or because of the seller's assurance that the goods conform to the contract. To effectuate this revocation, the buyer must notify the seller within a reasonable time after discovering the defect and before any substantial change in the goods occurs that is not caused by the defect. With regards to enforceability, there is something called bearing the risk of a mistake. A party bears the risk of a mistake when the risk is allocated to him by agreement on the parties. He is aware that the time the contract is made, that he has only limited knowledge with respect to the facts to which the mistake relates but treats his limited knowledge as sufficient, or the risk is allocated to him by the court on the ground that it is reasonable in the circumstances to do so. So there are defenses to enforceability based on change in circumstance. So frustration of purpose, this was found in Commerce Park. The occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. Event frustrates the purpose for entering the contract. The party asserting defense is without fault. The party asserting defense did not bear the risk of event occurring. For example, the Queen of England gets sick first and there is no coronation to watch from the rented balcony. Or another example is the software the contract explicitly intended to provide the world's first AI program, but another company releases an AI program first. Essentially, you intend and contract on something, but first something bad happens, and it makes the contract pointless. This is an example to defense to enforceability based on change in circumstance. Also, there is the impracticability defense to enforcement, and this was found in material sand and stone case. The occurrence of an event, the non occurrence of which was a basic assumption on which the contract was made, or the event renders performance impracticable. Party asserting defense is without fault. Party asserting defense did not bear the risk of the event occurring. This is a more expensive. So when it comes to impracticability, this usually happens when it's more expensive or there's a significant time difference in order to get the contract executed. That is impracticability. So the another defense to enforcement is impossibility, and this was found in the case of World of Boxing. So with regards to impossibility, this is where the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, event renders performance impossible. Party asserting defense is without fault. Party asserting defense did not bear the risk of the event occurring. And essentially, this is based on one example of impossibility is a leased building is destroyed. So it's impossible to lease out a building that's destroyed. It's no longer a building. Also, death is another example of impossibility defense to enforcement of a contract or agreement. So there are defenses to enforcement based on social and moral limits. So when it comes to mutual assent, one can say we have no enforceable contract because one party was a minority. And when we say minority, we mean a person who is not of age to engage in a binding contract. With regards to not being able to mutually assent to a contract, there's minority, and then there's incapacity, intoxication, duress, and undue influence. Another category of defenses to enforcement of a contract based on social and moral limits is consideration. A person can say we have no binding agreement because the event occurred to where it was impossibility to execute the contract, or there was a frustration of purpose to execute the contract, or it's impractical. I always have trouble saying that. I'm so sorry. Impracticability to enforce the contract. Okay, the third category is other social boundaries. So a person could say we have no binding contract because the terms of the contract are illegal. You can't have a contract for murder. And sometimes it's things not that blatant. Things like, oh, I'm going to sell you this horse for, I don't know, $30,000. But then there's a statute passed before the contract is executed saying one cannot sell a horse without having a horse seller license when that law didn't exist before at the beginning of the contract terms. But so there's illegality, violation of public policy, or unconscionability. Those are examples of defenses to enforcement of a contract based on other social boundaries. Another defense to enforcement is based on lack of mutual assent. And this can be seen by information asymmetry, where it is acceptable and where it is unacceptable. There are also mistakes that can be present in an agreement that can be a defense to enforceability. And the different defenses or the different mistakes are mutual or bilateral mistakes. Those are mutual equals bilateral mistakes, as well as unilateral mistakes, as well as fraudulent misrepresentation, fraudulent concealment, and things like that. So when it comes to defenses to enforcement based on lack of mutual assent, information asymmetry is acceptable when, well, basically in Anglo-American courts, we don't require you to disclose all of the information you have when you are litigating a contract. Anglo-American courts have incentivized competitive advantage. Courts don't want all parties to know all of each other's information. Information asymmetry is unacceptable when there are circumstances where the court will intervene based on asymmetrical information. If you bear the risk, you cannot use this defense. Mutual mistake, unilateral mistake, not fraudulent misrepresentation, and fraudulent concealment can be used as unacceptable asymmetry examples. So when it comes to a mutual mistake, this is a defense. We went over this before, but it doesn't hurt to go over it again. Mistake of both parties relates to basic assumption on which contract was made. Material effect on agreed exchange. Parties seeking avoidance did not bear the risk of mistake in contract terms. Material effect on agreed exchange may consider any available relief other than voiding the contract. And that is a mutual mistake defense to enforceability. So a unilateral mistake defense, this is where the mistake of one party relates to basic assumption on which the contract was made. Material effect on agreed exchange adverse to mistaken party. Mistaken party did not bear the risk of mistake in contract terms, and the effect in policy is unconscionable, or the non-mistaken party had reason to know of the other's mistake, or the non-mistaken party's fault caused the other party's mistake. So the reason to know, not actual knowledge, is required. Just reason to know is required, not actual knowledge. Another thing that's required is the non-mistaken party caused the mistaken party to misthink, or the judge finds unmistaken party's conduct to be unconscionable. Promissory estoppel may kick in if this is the case. If there's a defense of unilateral mistake and the judge recognizes the defense, then promissory estoppel may kick in to enforce that contract. Then there's fraudulent misrepresentation. This is a defense as well as a cause of action. A false statement or representation of facts made by one party to the other. The misrepresentation relates to a fact that is material to the exchange. The misrepresentation is intended to induce the other party to enter the contract. The party seeking to avoid the contract reasonably relied on the misrepresentation in entering the contract. A misrepresentation is material if it would be likely to induce a reasonable person to manifest his assent, or if the maker knows that it would be likely to induce the recipient to do so. So when it comes to fraudulent misrepresentation, this requires fraudulent intent. So the damages with regard to fraudulent misrepresentation include punitive damages and constructive trust. This is for, fraudulent concealment and fraudulent misrepresentation. So when it comes to fraudulent concealment, this is a defense as well as a cause of action. The failure to disclose a fact amounts to a misrepresentation when the party knows the disclosure of a fact is necessary to prevent some previous assertion from being a misrepresentation or from being fraudulent or material. Where he knows that disclosure of the fact would correct a mistake if the other party as to a basic assumption on which the party is making the contract, and if the non-disclosure of the fact amounts to a failure to act in good faith and in accordance with the reasonable standards of fair dealing. Where he knows that disclosure of the fact would correct a mistake of the other party as to the content or effect of a writing, evidence, or embodying an agreement in whole or in part. Where the other person is entitled to know the fact because of a relationship of trust and confidence between them. So fraudulent intent is required for fraudulent concealment rather than unilateral mistake. With regards to enforceability, a defense can be the violation of public policy. So when it comes to violation of public policy, this is where a contract cannot contain terms that break the law or harm society. The legislation provides performance is unenforceable, or interest in enforcement clearly outweigh the public policy against enforcement. Interest in enforcement, it basically asks what to look for after reading the facts. So what you want to look for after reading the facts is parties justified in their expectations, any forfeiture that would result if enforcement were denied, any special public interest in enforcement of the promise or term. So the interest against enforcement, you want to ask yourself, What to look for after reading the facts. What you want to look for is strength of policy as manifested by law or judicial decision, likelihood that refusal to enforce will further public policy, the seriousness of any misconduct involved and deliberateness of it, directness of connection between misconduct and terms. Another policy that can be used as a defense to enforceability of a contract along with violation of public policy is unconscionability. This is where contracts that have grossly oppressive and unfair terms that shock the conscience of the reasonable person. It is an equitable defense. Procedurally unconscionable can be described as process of bargaining that is so unfair as to indicate there is some failure of mutual assent, and procedural bargaining questions to ask, having read the facts, are: did the parties seeking to avoid the contract have any meaningful opportunity to negotiate the terms, or was it a take it or leave it type of proposition? Are there terms in a difficult to read contract that are hidden and would reasonably surprise the parties seeking to avoid the contract? Is there a significant disparity in bargaining power and sophistication? Also, substantially unconscionable. So that's procedurally unconscionable. Now we're going to get into substantially unconscionable. Are terms of contracts that are so unfair as to violate principles of consideration. Substantive terms and questions to ask, having read the facts, are ultimately determined on a clause by clause basis. Are the terms so extreme as to appear unconscionable according to the morals and business practices of the time and place? Does the particular term seeking to be avoided apply to both parties or only to one? Or does it have a modicum of bilaterality? Does the particular term impose an expense that is unjustified or that is otherwise prohibited by local policy? Does the particular term effectively shield the stronger party from liability for its actions? So, is it specific to arbitration? Say, for example, is the arbitration location very far away? Like, you sign a contract in California, but the arbitration clause in the contract says, well, if you have any disputes about this contract, we're gonna have to go through arbitration, and arbitration is gonna be in Fiji only. No other place except Fiji can this dispute be heard. That is specific to arbitration. And that's a question to look for when trying to see if a contract is unconscionable based on substantively unconscionable. So cases that show unconscionability: Williams v. Walker, Thomas Furniture. This is where one can argue replevins spelled REPLEVINES. This is basically saying, give me my stuff back. This is a procedure whereby seized goods may be provisionally restored to their owner pending the outcome of an action to determine the rights of the parties concerned. The judge determines if it was present at all, and the jury looks at the facts, and essentially the courts will interfere when something went wrong when the parties intended to manage the risk. Interpretation and rules of construction of an agreement contract. So some of the basic things that a contract would need, particularly for UCC, is it must be in writing with requirements, and that's an example of statute of frauds. It must identify the subject matter of the contract. It must list essential terms. It must state that an offer or contract is made, and it must be signed by the party to be charged. So the general requirements for a memo or memorandum. So the rules of contract construction. Contracts are construed as a whole. The words are generally given their ordinary meaning. Written or typed terms prevail over printed, custom, and usage in business, and locale is considered. Courts will try to find contract valid, and ambiguities are construed against the contract's preparer. And just to reiterate, written or typed terms prevail over printed terms, and custom, and usage in business and locale is considered. So the general requirements for a memorandum say, unless other requirements are needed by the statute, a contract within the statute of frauds is enforceable if it is evidenced by any writing signed by or on behalf of the party to be charged, which reasonably identifies the subject matter between the parties or offered by the signer to the other. It reasonably, reasonable certainty, the essential terms of unperformed promises must be listed. And with regards to the signature, it may be a symbol made or adopted with the intention to authenticate the writing as that of the signer. So with regard to the UCC statute of frauds, the statute of fraud requires that the contract for sale that the contract for sale has been made and it must include quantity or otherwise it's unenforceable. The contract for a good, if it omits or misstates a term, doesn't need all material terms and they need not be precisely stated. Essentially, writing is the basis for believing that the oral evidence rests on a real transaction. And within the UCC, it's within a narrow scope regarding sales of goods. Honestly, it's a better gap filler than the common law. So just to clarify something, a contract is valid if it omits or misstates a term because you don't need all material terms and those material terms do not need to be precisely stated. With regards to rules of construction of an agreement contract, the terms must be clear or clarifying terms. The general obligation of good faith and fair dealing must be present or is already present. And there is the parole evidence rule. This was all explained earlier in the video. Now we're going to go into the statute of frauds in more depth. So with regards to statute of frauds, what you want to ask is the contract enforceable? Does it have to be reduced to writing? With regards to promissory estoppel, is there a pre-existing duty to replace consideration in a contract? The policies that we want to look at with regards to the statute of frauds is evidence. And evidence wants to, a court wants to see evidence in order to find if the contract should be enforced. It's a form of channeling. Cautionary purpose is also a policy implement for the statute of frauds. With regards to cautionary purpose, it's to encourage people to take more care when entering such transactions. And with regards to predictability, the statute of frauds is essentially constructed to set expectations about those goods. So we have gone over before that the statute of frauds basically requires that certain transactions be reduced to writing. And this, there are exceptions to the statute of frauds. Exceptions include reliance, partial performance, judicial admission, and extrinsic evidence admitted to see the meaning of terms, to see if essential terms are present. So with regard to the statute of frauds, common law and UCC handle things differently. Statute of frauds means certain transactions have to be reduced to writing. So in common law, when there are new or different terms, the agreement is only on matching terms. New terms are proposals. Differing terms are knocked out. With regards to contracts between merchants, the UCC says new terms are included unless there is an offer that prohibits new terms from being included. Terms materially, with regards to new terms not being included is if the terms materially change the deal or rejection of the new terms are communicated. And that's a statute of frauds rule with regards to the UCC. And so there are a couple of exceptions. For example, new terms are not added. The contract exists on matching terms. That's the mirror image rule. If there are gap fillers available, if applicable, And, the mirror image rule applies to common law, and the gap fillers usually applies to UCC. But we're going to explain all this in detail in the next few minutes. Exceptions to the statute of frauds. So, especially made goods and part or partial performance. Under the UCC, if the goods are to be specially manufactured for the buyer and are not suitable for sale to others in the ordinary course of business, and the seller has made a substantial beginning of their manufacture, then that may be an exception to enforcing a contract based on the statute of frauds exception. And this was found in Buffalo v. Hart. So, detrimental reliance under the UCC, one might say that promissory estoppel is always available because promissory estoppel is not an express contract, and the statute of frauds does not apply to contracts implied in law. This was found in Alaska Democratic Party v. Rice. Also, confirmatory memos. Under the UCC, a memo is received by a party to a contract between merchants within a reasonable time of the sale, and no objection is received by the other party within 10 days. This was found in St. Ansgar Mills versus Strait. And basically what we're doing is we're listing exceptions to the statute of frauds, and we'll continue. Partial performance. When it comes to land under the common law, that is an exception to the statute of frauds. Also, judicial admissions. Say, for example, if one party admits to doing something that they should not have done, some type of breach, then that can be an exception to the hard and fast rules of statute of frauds. Like, say, for example, if one party says, yeah, we agreed that it was going to be bumped up by 300%. We didn't put it in writing or anything, but then I started, adjusting my conduct to accommodate for the increase of 300%. And if they say that in court, then that's an exception to what's written down in the contract. In other words, I can say that is an exception to the statute of frauds, and that was found in Gibson v. Arnold. And that's true for the common law and the UCC. I don't think I explained this enough. When it comes to exceptions to the statute of frauds under the common law, when it comes to the transaction of land, partial performance with regards to land can be an exception to what's written down on paper or digital paper with regards to statute of frauds. So say, for example, if the contract is about land and it's under common law and there's partial performance with regards to the land, that wasn't written down, that can be an exception to the statute of frauds. There's a billion examples. One example is, say, for instance, someone has a tract of land but it's heavily treed, and somebody comes by and says, I want to buy this land, but for me to buy it at that price, I want the trees all cut down. And so one party is like, okay, I'll get the trees cut down for you. And so they cut down half the trees, and then the other guy says, you know what, I don't want to buy this land anymore. And the other party's like, are you kidding me? I spent all this money cutting down these trees, you better buy it. So an exception to the statute of frauds, even though the requirement to get the trees cut down before the sale of the land wasn't written down, the judge may see that it's an exception to the statute of frauds and have the other party to sell the land and finish cutting down the trees. Or they may have the other party buy the land even though there was partial performance in getting all the trees cut down. You know what? I don't know if I was very clear in that example. Let me try it again. Okay, so there's a piece of land and it has a lot of trees on it. And the buyer says, I'm looking to buy this piece of land. However, I'm not going to buy it unless all the trees are cut down. And so they make a contract and it says so-and-so will buy the land for, let's just say, $100,000. And so, but they don't put that the trees have to be cut down in order for the buyer to buy the land. It just says buyer will buy land for $100,000. So the seller starts, cutting down the trees. They get halfway, but then the buyer says, you know what? I don't want this tract of land anymore. I'm pulling out of the deal. Well, the seller says, I spent a considerable amount of money cutting down these trees for you to buy it. You're gonna reimburse me for at least cutting down the trees if you don't want to buy the tract of land for $100,000. And the buyer's like, you can't make me give you any money for cutting those trees down. It wasn't in the original contract. It was just spoken between us. Under the statute of frauds, everything about the sale of a land has to be written down in this contract. It's not written down, so I'm not giving you any money to reimburse you for cutting down those trees. Well, the seller takes the buyer to court, and the judge realizes this situation calls for an exception to the statute of frauds based on partial performance in the common law sale of a land. And so they'll make the buyer either, have them opportunity to buy the land for $100,000 or make them reimburse the seller for cutting down half of those trees. All right. I hope that was a better example, more clear and concise and compelling. Okay, we went over this before, but it bears repeating. With regard to the UCC, Section 2-2011, statute of fraud requirements include the contract for sale has been made already. All right, so that has to be established. There has to be an actual contract present. So the contract must include quantity, with regards to goods. Otherwise, the contract is not enforceable. And the contract is valid if it omits or misstates a term, because you don't need all the material terms and they need not be precisely stated. The writing is the basis for believing that the oral evidence rests on a real transaction. The writing isn't the final say-so. It's just the basis for believing that the oral evidence rests on a real transaction. And the UCC, with its narrow scope regarding the sale of goods, is a better gap filler than the common law. So there's plenty of exceptions to the UCC. There's plenty of exceptions to the statute of frauds found in the UCC. There are about 4 circumstances that can substitute for a signed writing. The first one is a confirming merchant memorandum, which is unique to Article 2. This is where the plaintiff's signature substitutes the defendant's signature. The second one is specially manufactured goods. This is reliance-based. The third one is judicial admission. And the fourth is part performance reliance-based. Okay, so with regards to a confirming merchant memorandum, which is unique to Article 2, this is where the plaintiff's signature substitutes the defendant's signature. This is under the UCC. It's between merchants. This is where a writing and confirmation of the contract and sufficient against the sender is received, and the party receiving it has reason to know its contents, as well as it satisfies the statute of frauds against this party unless the written notice of objection is given within 10 days after receipt. That is an exception to the UCC statute of frauds. And that's confirming merchant memorandum, which is unique to Article 2, where the plaintiff's signature substitutes the defendant's signature. So the second one is specially manufactured goods, and this is reliance-based under the UCC. And this applies to sellers, not buyers. Sellers. So the third one is judicial admission. This is also under the UCC. And this exception is described as saying, this applies to sale of goods. It is when one party admits through pleading or testimony or otherwise. This does not apply to quantity. So the fourth UCC exception to statute of frauds is partial performance, and this is reliance-based. Under the UCC, it applies to sellers and buyers. If seller partially performs or if buyer partially performs to the terms of the contract, then the judge may have the contract enforced or somebody reimbursed based on these UCC exceptions to the statute of frauds. Okay, so with regards to the statute of frauds, in the case of Buffalo v. Hartz, the specially made goods and partial performance. So under UCC Section 2-201, Buffalo Hart really gives a great example of this. If the goods are to be specially manufactured for the buyer and are not suitable for sale to others in the ordinary course of business, and the seller has made a substantial beginning of their manufacture, this may be an exception to the statute of frauds. Confirmatory memo. A memo is received by a party to a contract between merchants within a reasonable time of the sale, and no objection is received by the other party within 10 days. This was, exercised in St. Ansgar Mills v. Strait. Alrighty, so detrimental reliance. This is, one might say that promissory estoppel is always available because the promissory estoppel is not an express contract, and the statute of frauds does not apply to contracts implied in law. This was shown in Alaska Democratic Party versus Rice. The common law could happen in the UCC. And by that I mean promissory estoppel can be applied to UCC. However, it's unlikely because the UCC is so specific. So with regards to digital admission, this was found in Gibbs v. Arnold. This is where somebody admits in court or some type of legal document that the oral agreement was what parties were acting on, and it doesn't matter if it was written down or not. They intended to agree on it, and there's mutual assent. And this is true for common law and UCC, judicial admission. That's basically when you just tell on yourself. Yeah, I don't think I explained this clearly enough. When it comes to confirmatory memo, a confirmatory memo is a memo that's received by a party to a contract between merchants within a reasonable time of the sale, and no objection is received by the other party within 10 days. That is a confirmatory memo. Okay, we're going to be very detailed. We're going to go over this one by one. This is something that's been mentioned before, but it bears repeating in our statute of fraud section. So with regards to statute of fraud, the writing requirements for common law statute of frauds include three main categories. Reasonably identify the subject matter of the contract. The second one is the contract is sufficient to indicate that a contract with respect to the subject has been made between the parties or offered by the signer to the other party. And the third one is states with a reasonable certainty the essential terms of the unperformed promises in the contract. So let's get into the writing requirements for the UCC statute of frauds. Identify what the good is. The second one is method of determining the price. The third is some determined quantity that is more than zero, or some method of determining the quantity. And this was found in the case of Lohman v. Wagner. And the fourth one is, well, this isn't really an element, but it's easier to meet than the common law. And those writing requirements in the UCC for statute of frauds are easier to meet than the common law. So with regards to the statute of frauds, in reference to construction, this is true for UCC and common law. And what's true for UCC and common law is signature requirement. Signature requirement includes a symbol made or adopted with an actual or apparent intention to authenticate the writing as that of the signer. Also, there's alternative inscriptions are sufficient as signatures only when the party makes the inscription for the purpose of authenticating the writing as binding on him. And this was found in the case of Durham v. Harbin. All right, now we're going to go into modification. And of course, with everything in contracts, is split between two bodies of law, common law and the UCC, Uniform Commercial Code. Let's start with common law. So modification under common law, an agreement to modify an agreement. That's what modification under common law is. So each party's agreement to modify must be supported by consideration. It is a new or separate agreement and needs new manifestation of mutual assent and consideration. Under the Restatement, Second Edition, Section 89, modification of an executory contract includes three main items. If modification is fair and equitable, regarding circumstances not anticipated when the contract was made, or to the extent provided by statute, or to the extent that justice requires enforcement in view of material change of position in reliance of the promise, this needs additional consideration or changed circumstances to support modification under the common law. So that was a little fast. Let me break it down a bit more. Under the Restatement, Second Edition, Section 89, modification of an executory contract. So in the common law, if the modification to the contract is fair and equitable, with regards to circumstances that were not anticipated when the contract was made, or say, for example, modification of a contract is valid under the common law to the extent provided by statute, or modification of a contract is valid by common law if the modification is made to the extent that justice requires enforcement in view of material change of position in reliance on the promise. With regards to modification being enforced under common law, it it would need additional consideration or changed circumstances to support modification under the common law. And essentially, that's saying a common law contract is valid if the modifications are met with additional consideration or if the modifications were made due to a change in circumstance. So let's get into modification under the UCC. So signed writings serve the function that consideration does in the common law. And let's just remind ourselves from 2 seconds ago. With regards to common law, a modification of a contract is valid when there is new consideration, new mutual assent, new everything. Okay, so under modification under UCC, it protects the need of consideration to enforce modification. Also, signed writings make modifications legally binding under the UCC. Also, under the UCC, there may be clauses such as no oral modifications or NOM, N-O-M acronym. So, modification, rescission, and waiver. When it comes to the modification of rescission and waiver, one can describe it as it does not address the hold-up game. Modifications must meet the test of good faith and good faith imposed by the actions of the parties. Bad faith used to escape performance on the original contract terms is barred, and extortion of a modification without legitimate commercial reason is ineffective as a violation of the duty of good faith. Also, therefore, the holdup game does not work under UCC Article 2209. The contract would not be legally binding if the judge sees that there's a holdup game within the party's conduct. And basically, the holdup game is where one party demands more money at the time of exchange. So good faith essentially is just honesty, standards of fair dealing, reasonable people in business. Exercise good faith. So just to be blunt, when it comes to the UCC modification rules, an agreement modifying a contract within the UCC does not need consideration to be binding. Also, a signed agreement which includes modifications except by a signed writing can't be otherwise modified. Let me just make sure I clarify that second one. A signed agreement which excludes modifications except by a signed writing can't be modified. Okay, so let's dig into some more exceptions with regards to modification. So in the common law, detrimental reliance is an exception to the modification rules. It basically circles around fairness. Even though the common law requires new consideration, the modification may be legally binding despite the lack of new consideration. And this is based on detrimental reliance defense. And as we mentioned earlier, but I think it bears repeating, under the common law, an exception to their modification rules is if there are changed circumstances. And again, it circles around fairness. A modification can be binding if it is fair under the common law. A modification can be binding in light of the changed circumstances. A change in circumstances can substitute for that new consideration. And another exception to the common law modification rules circled around fairness is price increases can be fair with more work added. All right, so that's not the hold-up game. There is a possibility that a contract can disallow oral modifications. That's the NOM clause, no oral modifications. Also, the written waiver provision. This is where a modification can be legally binding if there are changed circumstances. Again, that's just for fairness. So with regards to exceptions and modification, those are your four exceptions. Written waiver provision, disallowing oral modifications, the non-provision, that's in the UCC. Under the common law, changed circumstances if they are fair, and detrimental reliance if it is fair under the common law. And when we say circumstances, change of circumstances, that includes what we mentioned earlier: frustration of purpose, impracticability, impossibility, and also there are defenses based on social and moral limits, but we want to focus on the change in circumstances: frustration of purpose, impracticability, and impossibility. All right, so with regards to remedies, we didn't go very deep into that during the fall semester 2023 for the class of 2026 in Contracts 1. Remedies, they do include restitution of quasi-contracts. We didn't go into it, but one of the remedies that we did go into that we spoke about earlier is unjust enrichment. And this is found in the cases of Webb v. McGowan, Harrington v. Taylor, Commerce Partnership 3098 Limited Partnership versus Equity Contracting Company, and Griffith Blacktop Incorporated versus Richard Dillon. So restitution prevents unjust enrichment, which is where it's unfair for one party to retain the benefit without compensation. Generally, the recovery is the value of the benefit conferred on the recipient, not the loss to the party seeking restitution. The injured party is entitled to restitution whether or not there's an enforceable agreement. It's usually monetary. One party confers a benefit on another, and under the circumstances, it would be unfair to permit the other party to retain the benefit without compensation. That is unjust enrichment. And usually because the other party knew or had reason to know that the party conferring the benefit reasonably expected compensation, usually the benefit was not intended to be a gift. That is unjust enrichment. Okay, and my contracts professor said what really separates a B essay exam answer from an A essay exam answer is that the A essay exam answer includes policy, and essentially policy says why this rule, why this statute exists at all. So we're going to go down a very extensive list of the different policy categories and elements that are present in contract law that we went over in class. So freedom of contract, also known as private ordering, also known as private autonomy, also known as respecting the intent of the parties to contain private ordering, has reliance and predictability. There's also economic efficiency, which is to prevent unjust enrichment and promise private autonomy. There's also evidentiary function of these contracts, rules, and laws. And for evidentiary function of the statute of frauds is to provide documentation that is illegal, binding, and binding agreements exist, or it's proof that binding or evidence that binding agreements exist. So the cautionary function to these rules and laws for contract law of the statute of frauds, it's meant to make each party more intentional, serious, and deliberate in their transacting. When it comes to channeling, it's to make sure that the parties understand and could organize their behavior around a clear distinction between legally enforceable and unenforceable promises. That is channeling. And then there's violation of public policy. A contract cannot contain terms that breach law or harm society. And then there are a couple of aspects to that. Legislation provides performance is unenforceable, or the interest in enforcement clearly outweighed by public policy against enforcement of the contract, or the interest in enforcement. With regards to interest in enforcement, what you want to look for after reading the facts is are the parties justified in their expectations? Is any forfeiture that would result if the enforcement were denied? And if there are any special public interest in enforcement of the promise or term. Also, when it comes to interest against enforcement, what you want to look for after reading the facts is strength of policy as manifested by law or judicial decision, likelihood that refusal to enforce will further public policy, seriousness of any misconduct involved and deliberateness of it, and directness of connection between misconduct and terms. So those are the different aspects of the violation of public policy. Now we're going to get into the last one, unconscionability. This is where a contract is so grossly oppressive and unfair in its terms that it shocks the conscience of a reasonable person. And this is an equitable defense. So there are a couple of different categories to unconscionability. There's the procedurally unconscionable, the substantively unconscionable, and what the judge determines to be unconscionable. All right, so under procedurally unconscionable, the process of bargaining are so unfair as to indicate that there is some failure of mutual assent. And the other elements of procedurally unconscionable policy is procedural bargaining questions to ask, having read the facts, are: did the parties seeking to avoid the contract have any meaningful opportunity to negotiate the terms, or was it a take it or leave it proposition? Are there terms in a difficult to read contract that are hidden and would reasonably surprise the party seeking to avoid the contract? And is there a significant disparity in bargaining power and sophistication? So another category of unconscionability is substantively unconscionable. Terms of contract that are so unfair as to violate principles of consideration. Substantial or substantive terms and questions to ask, having read the facts, are ultimately determined on a clause-by-clause basis. Are the terms so extensive as to appear unconscionable according to the morals and business practices of the time and place? Does the particular term seeking to be avoided apply to both parties or only to one? Or does it have a modicum of bilaterality? Does the particular term impose an expense that is unjustified or that is otherwise prohibited by local policy? Does the particular term effectively shield the stronger party from liability for its actions? And this is specific, or is the substantively unconscionable term specific to arbitration. An example case is Williams v. Walker Thomas Furniture Company. So the judge determines, and lastly, the judge determines if it was present. So what I'm trying to say is, when it comes to the unconscionability policy, the last category is the judge determines if there was unconscionability present at all, and the jury looks at the facts, and the courts will infer when something went wrong, when the parties intended to manage the risk. And that is my Contracts Law 1 review. Thank you. And so let's just, give a quick list of the seven the seven policy categories. There's freedom of contract, economic efficiency, evidentiary function, cautionary function, channeling, violation of public policy, and unconscionability. Those seven things are the reasons why contract law rules and laws exist. Let's just go over them again. 1, freedom of contract. 2, economic efficiency. 3, evidentiary function. 4, cautionary function. Channeling. 6, violation of public policy. 7, unconscionability. Yes, I'm going to do it a third time. I just want to make sure that you understand these policies because from what my professor said, they really separate the A papers from the B papers. So these rules and laws for contract law are to promote freedom of contract. They are to promote economic efficiency. They are to promote evidentiary function. They are to promote cautionary function. They are to promote channeling. They are to prevent violation of public policy. And they are to prevent unconscionability. Thank you.